Jury Charge Performance Challenge, week number 14. Paragraph. Ladies and gentlemen of the jury, At this point in the trial, I am required to inform you as to the law governing this case to guide you in your deliberations, period. This statement by the judge as to the law of the case is known as the charge, semicolon. It is also called instructions, period, paragraph. It is my duty to preside over the trial and to determine what testimony and evidence is relevant under the law for your consideration, period. It is also my duty at the end of the trial to instruct you on the law applicable to the case, period, paragraph. You, as jurors, are to decide the facts, period. But in determining what actually happened in this case, that is, in reaching your decision as to the facts, it is your sworn duty to follow the law that I am now in the process of defining for you, period, paragraph. You must not change the law or apply your own idea of what you think the law is or should be, period. Both you and I are bound by the law as stated in this charge, period, paragraph. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole, period. Neither are you to be concerned with the wisdom of any rule of law as stated by me, period. Regardless of any opinion you may have as to what the law is or ought to be, it would be a violation of your sworn duty to base a verdict upon any view of the law other than that given in the instructions of the court, just as it would be a violation of your sworn duty, as finders of the facts, to base a verdict upon anything other than the evidence in the case, period, paragraph. Nothing said or done by the lawyers who have tried this case is to be considered by you as evidence of any fact, period. Opening statements of the lawyers are intended to give you a brief outline of what each side expects to prove so that you may better understand the testimony of the witnesses, period. The closing arguments are often very helpful in refreshing your recollection as to the testimony of the witnesses, and as such facts may be developed thereby, but it is my duty to caution you that your verdict shall not be based upon the statements made to you by the lawyers at the opening of the trial or upon their closing arguments, period, paragraph. The function of the lawyers is to point out those things that are most significant or most helpful to their side of the case, and in doing so, to call your attention to certain facts or inferences that might otherwise escape your notice, period. In the final analysis, however, it is your own recollection and interpretation of the evidence that controls in the case, period. What the lawyers say is not binding upon you, period. Your verdict shall be based upon the evidence as you heard it from the witness stand, comma, and as you remember it, comma, not as the lawyers or this court may remember it, period, paragraph. The evidence in this case consists of the testimony of witnesses who have appeared before you and testified, and the exhibits which have been introduced in evidence and which have been shown to you, period, paragraph. The law makes no distinction between the weight to be given to either direct or circumstantial evidence, period. It requires only that you weigh all of the evidence and be convinced of the guilt of the defendant beyond a reasonable doubt before he can be convicted, period, paragraph. You should carefully consider the testimony of each and every witness and not overlook any testimony or evidence, period. This does not mean, comma, however, comma, that you must accept all the testimony as true or accurate, period, paragraph. You are the sole judges of the credibility or believability of each witness and the weight to be given to his or her testimony, period, paragraph. The court has admitted into evidence for your consideration a statement made by the defendant to police officers, period. If you believe that this statement was made by the defendant freely and without harassment, comma, then you may consider such statement as part of the evidence in this case, comma, and give to such statement and to each part of such statement such weight and credit as you may believe it is entitled, period. You may believe or disbelieve all or any parts of that statement, period. However, comma, if you do not believe that the statement was freely and voluntarily made to the police officers, comma, then you have the right to reject the statement from any consideration by you, period, paragraph. This is a criminal prosecution, comma, and the rule as to the amount of proof in this case is different from that in civil cases, period. A mere preponderance of the evidence does not warrant the jury in finding the defendant guilty, period. Before he can be convicted, comma, you must be satisfied of his guilt beyond a reasonable doubt, period, paragraph. The law presumes a defendant to be innocent of crime, period. Thus, comma, this defendant, comma, although accused, comma, begins the trial with a clean slate, comma, with no evidence at all against him, period. This presumption of innocence stays with him through every stage of the trial, comma, unless and until the state proves his guilt beyond a reasonable doubt, period. The defendant is never required to prove that he is not guilty, period. The law permits nothing but legal evidence presented before the jury to be considered in support of any charge against the accused, period. So the presumption of innocence alone is enough to acquit him, comma, unless you, comma, the jurors, comma, are satisfied beyond a reasonable doubt of his guilt after careful and impartial consideration of all the evidence in the case, period. Paragraph. The burden is always upon the prosecution to prove guilt beyond a reasonable doubt, period. This burden never shifts to a defendant, period. The law never imposes on a defendant in a criminal case the burden or duty of calling any witnesses or producing any evidence, period. Paragraph. The jury will remember that a defendant is never to be convicted on mere suspicion or conjecture, period. You do not have to believe that the defendant is innocent of the charge against him in order to find a verdict of not guilty, period. Your verdict of not guilty only means that the prosecution has failed to prove to you the guilt of the defendant beyond a reasonable doubt, period. Paragraph.